Muslim law of marriage and divorce. If a Muslim husband has falsely charged his wife with adultery, the process of retracting is called li'an. Under the Muslim law, khulla mubarat at are forms of dissolution of marriage by agreement. Which one is not a source of Muslim law? Sariyat. On the ground of fosterage, a Muslim marriage is void, batil. Which of the following are the source of Muslim law? Quran, Ijma, Qiyas. The legal guardian of Muslim minor female is father. Dower in Muslim law is an obligation imposed upon the husband as a mark and respect of wife, consideration for marriage, a legal right of the wife. Talaq-e-biddat is the complete and irrevocable divorce. A Muslim goes to any country of the world with an object of obeying the law of the country concerning with the include personal law. Marriage in Muslim law is civil contract. What is the age of puberty for a Muslim marriage? 15 years. After the death of the husband, a Muslim wife can retain possession over husband property until dower is paid. This right of her is called retention. According to Sunni law, the chief source of Muslim law are Quran, Hadith, Ijma, Qiyas. The Muslim Women Protection Right and Divorce Act was enacted in the year 1986. If the Muslim minor has contracted in marriage in his minority by guardian, such a person has right to attain majority to repudiate the marriage. This is known as Muslim law as Khayar-e-Bigul. A contract of the marriage between A and B is made in a joke without any specific intention. Such marriage is valid under Hanfi law. If A makes a hibba of certain property to B with the condition that B shall transfer the property, then condition is void and the hibba is valid. After declaration of waqf, the property became vested in God. A Muslim woman deserted by her husband without divorce is entitled to maintain under Section 125 of CRPC has been declared by Supreme Court in the case of Muhammad Ahmad Khan versus Sahabano Begum, 1985. Ijma as a source of Muslim law means unanimously opinion of Muslim jurist. In which one of the following cases Supreme Court has held that marriage of all persons who are citizens of India belonging to various religions should be made compulsory registrable in their respective states. Seema versus Aswin Kumar. Which of the following is not a ground of divorce under Special Marriage Act 1954? Conversion. Under Muslim law, following guardians of the marriage of a minor: father, brother, mother, state. Mutta marriage come to an end by Hibbai Muddat. A Muslim woman need to observe Iddat in which one of the followings? Mutta marriage, irregular marriage, valid marriage. Khilwat as-Sahi connotes valid retirement. The dower date is an actionable action. Which one of the following is the legal consequences of divorce under Muslim law? The party acquire right of contract to another marriage, cohabitation become unlawful, mutual rights of inheritance cease. When a Muslim mother loses her right of hijanat by apostrophe, by misconduct, by marrying with the decree of prohibited relationship. Among the following, which school does not mention a minimum amount of dower? Safai. Implied and contingent talaq is not approved by Shia. A Muslim woman can seek a divorce if husband is not traceable for a period of 4 years. Under Muslim Women Protection of Right of Divorce Act, the option of governing by the provision of Section 125 may be given by the parties to either jointly or separately. A Muslim divorced woman can apply directly to the Waqf board when there is no relative to support her. This was held in which one of the following cases? Secretary, Tamil Nadu Waqf Board versus Sayyid Fatima Nachi. Am the mother of a Muslim minor daughter contracted her in marriage in the lifetime of father who has become an apostrophe. The marriage is valid. A marriage of a Mohammedan who is of sound mind has attained the puberty is about without his consent. The marriage will be irregular. Which one of the following is secondary source of Muslim law? Custody. Which one of the following modify application of the Muslim law? Muslim Marriage Dissolution Act 1939, Muslim Women Protection of Right to Divorce Act 1986, Shariat Act 1937. Who applied Qiyas for the first time as a source of Muslim law? Imam Abu Hanfi. Which one of the following is absolute incapacity for marriage? Consanguinity, affinity, fosterage. Muslim can marry any number of wives, not exceeding 4. If Muslim marry a 5th wife, such marriage shall be irregular. After divorce, a Muslim woman can marry only after completion of iddat. How many witnesses are necessary in Shia Muslim marriage? No witnesses is required. Which one of the following is a wife rights when her husband does not pay dower? Refuse consummation, file suit for recovery of dower, keep possession for the dead husband of the property. Custody of illegitimate children belong to mother. Essential requirement of a Muslim marriage are both Qabul and Izab. During the term of Mutta marriage, neither husband nor wife has right to divorce. In Muslim marriage, where the age of the bride is below the age of puberty but consent for marriage was given by the guardian, the marriage is voidable. A marriage between the person with consanguinity relationship under Muslim law is batil. Under Muslim law, the marriage, whether consummated or not, iddat has been observed in the case of both husband and wife and the death of the husband, both divorce by the husband and the death of the husband. In Muslim law, divorce by lien is right available to the wife only. Under Muslim law, a prompt dower is payable when the demanded by the wife. In Mubarak, divorce under Muslim law, adhesive is mutta on the both sides. In Shia Muslim marriage, how many witnesses are compulsory requireable? No witnesses. A Muslim can marry a number of wives not exceeding 4. If a Muslim marry a 5th wife, such marriage shall be irregular. In which one of the following cases it was held that only in case of triple talaq halala is mandatory before remarrying the same husband? Muhammad Sahab Anand Sami versus Anand Sami. Under Muslim law, a man is forbidden to have two wives at the same time if related with each other by consanguinity, affinity, fosterage. What is iddat period prescribed for widow under Muslim law? 4 lunar months and 10 days. Under Muslim law, divorce by khulla is a divorce with the consent at the instant of wife. When is iddat observed for 3 months on divorce? Talaq which cannot be revoked after pronouncement is called talaq-e-bain. Under the Dissolution of Muslim Marriage Act, women can seek divorce from her husband if he is important at the time of marriage, if he continued to be important after the marriage. Whether a Muslim may give talaq in the state of intoxication under the pressure? Yes, recognized under Sunni Muslim law. By the third pronouncement, utterance of talaq, which kind of talaq became effective? Talaq-e-Hasan. In which one of the following cases the Supreme Court held that 3 talaq would be treated as a single talaq, not valid talaq? Sameem Ada versus State of UP 2002. Most proper form of divorce is asne talaq. Divorce by mutual consent in Muslim law is called khulla or muwarat. Khulla under Muslim law referred to divorce initiated by wife. Which one of the following enactments provide for ground of divorce available to wife only? Dissolution of Muslim Marriage Act 1939. In which one of the following cases Delhi High Court held pronouncement of a talaq 3 times a time by Muslim husband result to a single talaq? Masood Ahmad Khan. The Muslim Women Protection of Right to Divorce Act 1986 deal with maintenance right of divorced Muslim women. Which one of the following is not a ground of divorce provided by Dissolution of Muslim Marriage Act 1939? Conversion of the Hindu by some other faith. Which one of the following is not a form of a divorce in Muslim law? Fasid. The iddat period of divorced Muslim women who was pregnant at the time of her divorce is period between the divorce and delivery of her child or termination of her pregnancy, whichever is earlier. Which one of the following ground is not available to Hindu and Muslim wives both to claim divorce? Husband renounce the world entering into religious order, any religious order. Which one of the following is not available to Muslim wife to seek dissolution of marriage? Husband has changed the religion. Conversion of Muslim wife to some other faith not by itself operate at dissolution of marriage. The matrimonial remedy of judicial separation is not available under the following enactment: Dissolution of Muslim Marriage Act 1939. Impotency of the spouse is a ground for divorce under which one of the following matrimonial legislation? Dissolution of Muslim Marriage Act 1939. A man and woman both get married under classic Muslim law, then get their marriage registered under Special Marriage Act 1954. A year later, husband pronounced talaq on his wife, get married second time. The second marriage is void as the right of talaq is not available to the husband. Minimum of 2 years separation is necessary for obtaining divorce by mutual consent under the provision of Divorce Act 1869. The rule of unlawful conjugation under Muslim law related to Marriage of a man with his wife's sister. The matrimonial relief of annulment of marriage is not available under Dissolution of Muslim Marriage Act 1939. Mubarak under classic Muslim law referred to divorce by mutual consent. Whereabouts of husband is not known for a period of 4 years is a ground for divorce under Dissolution of Muslim Marriage Act 1939. Divorced Muslim wife in order to remarry former husband has observed the procedure of halala. Under the Muslim law, renunciation of Islam and conversion of the husband to any other religion would have the effect of instantaneous dissolution of marriage. Impotency is a ground for divorce under the Dissolution of Muslim Marriage Act 1939. Divorce by mutual consent in Muslim law is called Bharat. The most approved form of divorce under Muslim law is Talaq-e-Asan. The Muslim Women Protection of Right on Divorce 1986 enable as a Muslim woman to claim maintenance from her husband. Talaq can be effected by oral or spoken word in writing. A Muslim can be divorce his wife whenever he desired without assigning any cause but only in the presence of the wife. Which one of the following ground is not available to the Hindu and Muslim wife, both, to claim divorce? Husband renounced the word by entering into religious order. Which one of the following case of Delhi High Court held that pronouncement of talaq 3 times at a time of Muslim husband result into single talaq only? Masood Ahmad versus Delhi NCT. Divorce by mutual consent in Muslim law is called Mubarak. Which one of the following ground is not available to Muslim wife to seek dissolution of marriage under Dissolution of Muslim Marriage Act 1939? Change of religion by husband. Khula under Muslim law referred to divorce initiated by wife and accepted by the husband. Which one of the following enactment provide for dissolution of marriage at the instant of wife? Dissolution of Muslim Marriage Act 1939. Whether the consummation of marriage before and after the puberty deprive Muslim wife of her option of puberty under section 2(7) of Dissolution of Muslim Marriage Act 1939 does not deprive. Which one of the following preposition is correct? Muslim husband has right to have 2 wives. First wife has right to withdraw from the conjugal society. Husband cannot claim restitution of conjugal right. Muslim right of maintenance and divorce. The Muslim Women Protection of Right on Divorce Act 1986 deal with maintenance right of Muslim who had been divorced by their husband by the pronouncement of talaq, maintenance right of Muslim women who have sought divorce for their husband. Muslim law of inheritance. Under Hanafi law, the inheritance has derived among the distant kindred if there is no shares and residuary. In which one of the following case court held that doctrine acknowledgement is a part of the substantive Muslim law of inheritance, not a rule of evidence? Muhammad Allahabad Khan versus Muhammad Ismail Khan. Waqf Act. Which one of the following give meaning of the term beneficiary in Waqf Act 1995? A person or the object for whose benefit of Waqf is created, and also include religious, pious and charitable object and any other object of public utility sanctioned by Muslim law. Musliman Waqf Validating Act. Waqf can be made by Muslim only. Miscellaneous. What is the main source of Muslim law? Quran, Sunnat, Hadith, Ijma, and Qiyas. Acknowledgement of paternity once made under Muslim law cannot be revoked. In whose custody the Muslim illegitimate children will be kept? Mother. Which of the following gift is not valid? Gift of nature, conditional gift, gift based on wagering contract, and contingent contract. Muslim goes to any country of the world with an object to obeying the land of the laws of the country concerned, which include personal law. A divorced Muslim wife, unable to maintain herself, is entitled to be maintained by her former husband for a period till she remarries or dies. A married Muslim man changed his religion and became a Hindu. After 1 month, he got married to a Hindu girl. The marriage is valid as it was contracted after the conversion, with a result of automatic dissolution of Muslim marriage.